absorb what you were asking. Sorry about that.
Yeah, so because as far as I know, the meetings that I've been involved in, it's always been because the facilities were closed.
All right, so everybody is here. Zoom just had a little technical difficulties this morning, but everybody is here. And Emily, can
Absorb
you?
what you were asking. Sorry about that.
What's that, Cassandra?
So we're recording, we're live on YouTube, so I'm ready on my end whenever you're ready.
Great. Is everybody prepared to proceed?
Give me just 1 second.
Sure.
My computer's asking me to do things. I don't know why, but it is. So I apologize. I just want to make sure I have everybody who's here. The only person that I thought might be here who's not is David Mayfield. Will he be here?
Yes,
Oh, there you are. I see you now. You snuck in on me. Okay, thank you. All right. And I have a question for Lisa. Is it Gosinger? I just need to know the correct spelling of your name. It's different on the screen and it's different on the agenda. Could you spell it for me?
It's Gosiger, G-O-S-I-G-E-R.
And how do you spell Lisa?
It's Lissa, L-I-S-S-A.
Thank you. That's what I needed.
Yep.
Okay, I'm ready now. I just want to make sure I have those things before we started.
No problem. All right. Good morning. Everyone ready? All right. My name is Emily Supinger, and I'm the chair of the Zoning Board of Appeals. I'd like to take a minute to remind everyone about the rules of this proceeding. This proceeding is at all times governed by the rules of procedure adopted by the board and last amended January 17th, 2019. A copy of the rules of procedure is available for review online. This is a quasi-judicial hearing. As such, the board reserves the right to deliberate in private. The Ohio Rules of Evidence do not apply to this hearing. However, professional rules of conduct do apply, and candor to the tribunal is required. The board members are citizen volunteers and are not paid for their service. They are treated as public officials under Ohio law. Any attempt to influence them, including but not limited to bribery, intimidation, retaliation, which may include contacting their employer in an attempt to exert influence, is punishable as a crime. All should be aware that this meeting is being recorded. Therefore, please speak clearly into the microphone and state your name and address for the record. In the event of any technical difficulties with the video conferencing technology, I may continue or postpone this hearing at my discretion. All participants providing testimony must have both camera and audio features turned on in order to participate. With that said, let's proceed to the first case. And we have two cases today involving the same decision, case Z 4059-2021 and Z 4060-2021, both pertaining to 9 Far Hills Drive. Before we get into the two appeals, there are two pending items. The first was a motion of appellant appellee applicant Judith Johnson to present additional evidence. This pertained to, I think, an error in the ZHE decision that included a reference to the recording of a hearing held on June 4th, 2020. However, the hearing was actually March 24th, 2021. And Ms. Johnson is requesting that we, through this motion to admit additional evidence, correct this error. So I would look for a motion from the board to approve this motion.
So moved.
Is there a second?
Second.
Mr. Moran,
Aye.
Mr. Zelasco,
Aye.
Ms. Powell,
Aye.
and I vote yes as well. So we will correct the record in that respect. The second item is a notice of objection regarding to the written arguments that were submitted by Mr. Mayfield and Ms. Gosinger. That was also filed by Ms. Johnson. As the chair of the board, I have the discretion whether or not to grant or deny this motion. given that this material is already part of the record, we are going to overrule that objection, but it is noted for the record, Mr. Lindeman.
Thank you.
One other just procedural item. Because these appeals both involve the same case, what I would like to do is wait to do private deliberation until we've heard both arguments on both matters, if there's no objection from the board. So the way we will proceed is we will first hear the appeal of Mr. Mayfield and Ms. Gossinger. And once that argument has concluded, we will then hear the arguments from Ms. Johnson. Is that acceptable to everyone?
Motion to that.
Yes.
Yes.
That's acceptable.
Okay, great. So we will go ahead and proceed. Mr. Mayfield and Ms. Gossinger, you can go ahead.
Thank you. So thank you very much for having the hearing today. We're here essentially today from our point of view to consider the record in ZH case number 20210016, through which the owner of 9 Far Hills Drive, Ms. Judith Johnson, sought and obtained a variance for improvements to her pool house, which is accessory to her main house. And what we've argued respectfully is that that record from ZH 20210016, which was argued at the March 24th hearing earlier this year, indisputably shows that a related variance for improvements to the main house at 9 Far Hills Drive, the request for which was put in to the city by the same homeowner, the same applicant, and argued by the same lawyer, that request, that variance was fraudulent. The grant of that variance, was fraudulently obtained. And further, that the affirmation of that variance by the Zoning Board of Appeals was fraudulently secured by the applicant, who falsely reported the size and shape of the property known as 9 Far Hills Drive, and by the lawyer who relied on that false description of the size and shape on 9 Far Hills Drive to, in his argument that Ms. Johnson's variance request met the standard, the Duncan standard of practical difficulty, which is the law in Ohio, a standard that must be met. You all have seen, I believe, the description of the property that was submitted by the applicant in this most recent variance request. And I'd like to share my screen for a moment, if that's okay, just so we can review it. If I can do this correctly. Can you all see my screen?
Not yet.
What I'm trying to show here is a graphic description, aerial photography of the property known as 9 Far Hills Drive. The red outline shows the entire property known as 9 Far Hills Drive. It's composed of a number of different parcels that were originally platted, I believe, more than 70 years ago. And the red outline actually shows the limits of the property as described by Wes Munzel, the zoning plan examiner who compiled the administrative report for Mr. Sturkey's considerations in the most recent variance request. It shows essentially an estate that is 2.4 acres in size. It includes a primary residence on the left-hand side below the area that's hatched in purple. It shows a pool. It shows a pool house. It shows the platform that used to be an old platform for paddle tennis court. And it shows extensive gardens and acreage, all of which are owned by Judith Johnson, and all of which make up a single property known as 9 Far Hills Drive. And this essentially is how Mr. Linneman described the property in his arguments justifying the second variance request for the pool house. And it's clear why he described it this way. First of all, it's essentially truthful. It does describe the property known as 9 Far Hills Drive. And of course, he had to describe it this way because they were looking for a variance to make modifications and small additions to the pool house. But in the previous variance request, the same applicant, the same lawyer, posted a very different description of 9 Far Hills Drive. And it's essentially the area hatched in purple. That area that you see in the aerial photography here is what the applicant, Ms. Noble, the architect for Ms. Johnson, described as 9 Far Hills Drive. That's it, nothing further. Didn't include any description of a pool, no description of a pool house, no description of extensive acreage beyond the pool house. And the reason they described it that way is fairly simple to discern. The Duncan standard in Ohio is that the size and shape, the particular attributes of a property are what matters in applying the standard, because the key is that the property must have a particular attribute such that if the code were strictly applied, the property owner would be deprived of uses of the property which other property owners comparably situated to her enjoy. And the way they justified that here is they described the property in the previous request, which was only 107 feet wide by 90 feet deep, and all of the width of the property was taken up by the house, which you can see below the hatched area. And as a consequence, the only area that was available to Ms. Johnson, given the description of the property, was the area behind the house. And that justified, in Mr. Linneman's view, the very substantial variance that was granted by the city, a 32-foot variance to the 35-foot rear setback requirement. But the justification disappears when you consider how large 9 Far Hills Drive really is. Excuse me, just taking a quick peek at my notes. The questions, it seems to me, that this body needs to discern today are, number one, whether or not the zoning hearing examiner had the power, the responsibility, and the duty to take judicial notice of the fraud which was perpetrated on that body in the original variance request. Further, having taken cognizance of the fraud, which he was able to do, would have been able to do in this most recent variance request, because the evidence of the fraud was made obvious when the same applicant, the same lawyer, came forward to the city and described 9 Far Hills Drive as it actually should be described, a 2.4 acre piece of property with extensive accessory structures and appurtenances that cross a number of different parcels. The answer to that question has been determined, I believe, by numerous court decisions over the course of the past century, which suggest that a tribunal of original jurisdiction, such as the ZHE, has an inherent power to take notice of fraud perpetrated upon it, especially fraud that stems from a lawyer's violation of his duty of candor to the court. And that's what we have here. Mr. Linneman has shown in his testimony related to this case, the record for which is before you, that he knew that 9 Far Hills Drive was a 2.4 acre estate. In fact, in his testimony or argument that he put forward at the hearing, he suggested that anybody would have known this. All you had to do was look at the public record to see that 9 Far Hills Drive was a 2.4 acre estate composed of all this acreage. But that doesn't prove that anybody else knew it, that the city knew it. It only proves that he knew it, and he withheld that information from the Tribunal of Original Jurisdiction, the ZHE. And it had a direct impact on the ZHE, his withholding of that relevant material information. And it stretches credulity to think that that information wasn't relevant to the ZHE's consideration, when the Duncan standard is explicitly clear that the key to the standard is considering the circumstances of the property owner in question. That's the key. It's the law of the land in Ohio, and Mr. Sturkey's decision-making, his discretion, is completely constrained by that standard, the practical difficulty standard. He has no choice to go beyond, he can't go beyond it. His discretion is completely constrained by that. The reason why Mr. Linneman withheld the information is not because it was not relevant to the case. It's because it was directly material to the key to the case. And I believe that the case fails immediately. The case for the original variance request fails immediately if the information which Mr. Linneman now provides the ZHE and now provides the ZBA, if that were known at the time, it fails. The next question, it seems to me, that you have to answer is whether or not the ZBA can take judicial notice of an example like this of a previous judgment fraudulently obtained. And the law of the land is that you definitely can. Once again, a tribunal functioning as essentially the first court of appeals in this case has the same power inherent with it to police its own procedures, and the same power to take notice of the lawyer's violation of his duty of candor, especially when that violation to the tribunal, especially if that violation led in the initial case to a judgment related to a variance fraudulently obtained, and whether or not it impacted your own decision-making in the previous hearing that we had last fall. The next question, it seems to me, that you have to pose to yourself is, do you have the power to revisit an earlier decision made by the ZHE, not directly related to ZH 2021-0016? And once again, the common law of the land, established over centuries in the United States, but firmly established in a very famous Supreme Court hearing, Hazel Atlas versus Hartford Glass, I believe the name of the other company was, established that yes, there is no statute of limitations for all intents and purposes when it comes to fraud perpetrated on the Tribunal of Original Jurisdiction or perpetrated on the an appellate body who had review over a grant that was made by a tribunal of original jurisdiction. In that ruling, a 1944 ruling, the Supreme Court of the United States held that a fraud, which only came to light in 1939 about a patent case that was a patent that was originally granted in 1929 and an infringement lawsuit that took place in 1932 could all be revisited. And that in fact, the appellate court had a duty to revisit it once it was determined indisputably that a fraud had been perpetrated on the court, on first the patent office in that case, and then on the court when an infringement case was heard. And the court argued that the appellate body, the Circuit Court of Appeals, had the right and the duty to take notice of that earlier fraud and to direct the district court to correct its decision-making and take further action as necessary to sanction the misconduct and the bad faith. And that the Supreme Court had the power to direct the same. And that's what they did. This was a case where the evidence of the fraud emerged in a completely unrelated case. A 1944 case, 1939 case, excuse me, that was completely unrelated to the original patent. But what was exposed was a fraud on the part of the lawyer who participated in the original case, and they took action. And they had to take action. And the courts in the United States have ruled consistently that it's critical that that type of behavior be sanctioned in order to protect the administration of justice in this country. I would like to show you, just so you have it before you graphically. This is how the applicant originally described 9 Far Hills Drive. So that is the purple hatched area defined by the dark perimeter outlining the property, showing no room for an addition to the property to the right, fully obscuring the fact that this property had substantial acreage to the right, including a pool and pool house and platform tennis court and extensive woods. Here's how the same applicant presented 9 Far Hills Drive to the ZHE in the more recent case. Notice the pool, notice the pool house. Notice also that she didn't include the more extensive acreage, actually, which I believe most of which is subject to a conservation easement that extends out and composes the rest of the acreage, which makes up 9 Far Hills Drive. These two descriptions of the property are totally incompatible, and neither variance request would survive if you switch them, right? If the applicant and the lawyer had brought this description of 9 Far Hills Drive before the city when they were requesting a massive variance to the rear setback requirement in the earlier case, it would not have survived. It would not have survived scrutiny given the requirement for Mr. Sturkey to apply the practical difficulty standard in Ohio. It simply wouldn't have survived. It definitely doesn't survive if they brought this to the city when they came before the city requesting that rear setback variance. Interestingly, the new variance request doesn't survive, obviously, if the applicant and the lawyer brought this description of the property to the city, because there is no pool. There is no pool house in this description. question finally that you have to consider, it seems to me, is whether or not the applicant's silence on the real nature of 9 Far Hills Drive was untruthful. And whether or not Mr. Linneman's silence on the true limits of 9 Far Hills Drive in the first variance hearing was a serious violation of his duty of candor before the tribunal. I don't see how you can judge it any other way, given the key to the standard for deciding whether or not a variance has merit is the practical difficulty standard outlined and made the law of the land in the Duncan v. Middlefield decision in the 80s. It simply is impossible. Ms. Gosiger and I are here today asking this body to take judicial notice of the fraud which involves the current case and is fully proven by the evidence, written and otherwise, that makes up this current case. We're asking you to take judicial cognizance of the fraud and to recognize that any fraud like this, where a judgment has been obtained fraudulently, ipso facto, tramples on the constitutional rights of neighbors who are impacted by a variance which has been granted under fraudulent conditions, and the public. And we are asking you to exercise a power which is an inherent power held by all tribunals of justice to vacate prior decisions based on that fraud. And in this case, to remand the 2 variance requests back to the ZHE with instructions that they instruct the homeowner, the applicant, to put forward their variance requests again to the city together, such that the requests can, for the first time, be judged on the merits and not on a series of falsehoods and deceit. Thank you very much.
Thank you, Mr. Mayfield. Is there anything further from appellants before we? Okay, Mr. Linneman, you can proceed.
Good morning, and thank you to this body for your attention today. First of all, I apologize for the technical difficulties getting myself logged on today. Thank you for your patience. My name is Rob Linneman. I represent Judith Johnson, the owner of the property at issue. And I've been an attorney for 20 years. I'm licensed in 2 states, including the state of Ohio and Kentucky, United States Supreme Court, 6th Circuit Court of Appeals.
He's frozen on my end. Can anyone else hear him?
No, he's frozen.
Okay, I just wanted to make sure it wasn't just me. Thank you.
Cassandra, is the best thing at this point for him to log off and log back on?
I was just gonna give him a couple seconds and then I'm gonna give him a call and let him know. He might not even realize it. I'll give him a call.
Right, thank you.
He logged off.
Judith, I sent him an email and then I also called him twice. Are you have another number other than his cell phone, or have you heard from him by any chance? No. You're muted. I'm sorry, I can't hear you.
I haven't heard from him. All I have is his a number, which I think is, I can try. I'm not really sure I know how to do this. I'd have to leave the meeting though, right? In order to call him, or?
Well, I guess if you're on the phone, yeah, I will keep trying. I knew you had spoken to him earlier on. I didn't know if he had reached out to you. I will keep trying and I'll keep everybody posted.
Okay,
And if
thank
you
you.
have a way to contact him, that's great, but I'll keep trying on my end too.
Okay.
Okay.
Can everyone hear me?
Yes.
I apologize. I'm not sure what happened. Ms. Supinger, shall I continue then?
Yes, please, go ahead.
I apologize for the interruption. So let me, with the introduction I offered before, I will proceed straight to the merits here. First, the variance at issue is a relatively minor project. One thing that Mr. Mayfield didn't discuss at all, the actual project itself, which is an existing house, which is itself on a separate lot, and which would be eligible for without a variance for this reconstruction if the owner chose simply to make an application to treat it as a single family residence. The pool house that we're talking about here has been on the property for 60 years. So it's not the nature of any new disruption is that there isn't any. This is a house that's in need of some basic updates and repairs. At the hearing, Ms. Johnson testified that because it's got a flat roof, it is that roof has ultimately started to fail. The roof is leaking. The rotting wood is drawing animals, and the entire project, the house itself, is barely visible from the street because it is screened in behind a large amount of foliage and a privacy fence. And all of that would be disrupted if the city zoning staff had chosen to treat this differently, had not treated it as an accessory use, but had instead suggested that Ms. Johnson treat it as a residence. And this is where the distinction in the viewpoints between Mr. Mayfield and Ms. Gossiger and the rest of the neighborhood really diverges. The people who will actually have to see the project were asked these questions during the course of this hearing, and they all stated clearly that they would prefer that this project be treated as an accessory structure rather than an independent separate residence, because if it's treated as an independent separate residence, then Ms. Johnson will have to put in a driveway. She will have to make accommodation for parking. She will have to take out a privacy fence. That will result in taking down foliage that currently provides character to the neighborhood. The area where this is, where the pool house is located, is on a corner, and it has a very rustic, woodsy feel to it because of the existing foliage, because of the privacy fence. Now, Mr. Mayfield and Ms. Gossiger don't seem to care whether all that comes down and whether the neighbors who will actually have to look at it, they don't seem to care what their opinion is, because I asked this question directly of the neighbor, of the next door neighbor and of the neighbor across the street, and they were clear. They both objected to the idea that a driveway be put in there, that new curb cuts happen. Everybody agrees that would be more disruptive. And that is the outcome that'll occur here if this property can't be treated as an accessory structure and a variance can't be obtained for the relatively simple improvements that are being made. I should also say, just in terms of the scale of the improvements here, we're talking about an additional couple hundred square feet of space. And that is in the architect testified that is comprised almost entirely of a screened in porch, and even some portion of it is that the calculation of the additional square footage is because of the eaves of the structure itself. The zoning department, in its interpretation of this improvement, is forced to calculate space that you or I would not consider to be an interior space, improved space. It's actually an area that's underneath a porch. So in terms of the improvement itself, this is not a big project. This is not what's being proposed. If it goes forward as proposed, it will not be a disruption on the neighborhood and the neighbors. And the neighbors most closely involved have spoken on this, and they favor treating it as an accessory use rather than forcing Ms. Johnson to go through and treat it as a separate residence. But it would be permitted. She could do it. If the variance had been denied, she could walk right back in and get a permit to do the exact same improvement. She'd just have to knock down a privacy fence, a bunch of trees, and expose her neighbors directly to the pool house. But what you've heard so far, there is no question that the zoning hearing examiner, Mr. Sturkey, did his usual thorough work. He correctly identified the legal standard. He outlined, he found evidence in the record to support his decision. The appellants haven't criticized that in any respect. He applied the correct legal standard, and in that respect, this decision is sound. I probably don't need to remind this body, but of course, it is the case that the appellants bear the burden of proof in this proceeding, and it is their burden to show that the decision was illegal, arbitrary, capricious, unreasonable, or unsupported by a preponderance of the substantial, reliable, or probative evidence on the record. They have failed to do that. What they've made clear is they want another variance, a previous variance, to be set aside. Mr. Mayfield's case is that the misrepresentations were made, but his case is also that they were corrected in this proceeding, that the zoning staff and the zoning hearing examiner got, if they got correct information at all, they got it in this proceeding. So with that said, if the argument were to be accepted, the outcome of that would be that the current decision is based on correct information, the information that he deems to be accurate. And the outcome of that should be that this variance should be approved by this body. What the argument that's been raised by the appellants in this case raises a major problem for this body in terms of the relief that the appellants are seeking, because they are seeking the overturning or the vacation of a variance that was granted in October. That variance is not before this body today. This body, this is a record hearing, of course. I am confined to presenting to each of you evidence that occurred in the zoning proceedings that took place for the pool house proceedings. I don't have evidence that I can show you of the variance hearing that took place last summer. It's not in the record, and therefore, even if this body wanted to, even if this body was inclined to, it doesn't have that evidence in front of it. Mr. Mayfield has made all kinds of representations about what was said in a zoning hearing in a different case last summer, but this body doesn't have that evidence in front of it because the record doesn't contain it. So I'm at a disadvantage in attempting to defend it. But Mr. Mayfield and Ms. Gossiger certainly are at a disadvantage in terms of meeting their burden of proof. They can't do it because that is not there, because they don't have the evidence of that proceeding to show what false representations may have been made. So there is in some respects, Mr. Mayfield has posed a correct question, which is fundamentally, can this body go back and decide and vacate a variance that was granted last summer in a different case number, which has now become final, under which Ms. Johnson is free to go obtain a building permit. Mr. Mayfield has not represented whether that building permit is acquired or not, because that would require a separate order. We'd have to go vacate the building permit too, because once the variance was granted and approved by this body, Ms. Johnson was free to go get her building permit. He didn't raise that. He didn't explain what this body's to do about that. So there are a bunch of real just jurisdictional problems, and this body's jurisdiction is limited. This is not a common pleas court. I mean, no disrespect to this body, of course. This body has authority over this proceeding, but this is a statutory body, and the authority in this case is over the variance proceeding for the pool house. And frankly, we just haven't heard any evidence or any real argument about what was wrong, what was defective about the proceedings with the pool house variance. Mr. Mayfield and Ms. Gossiger's case relates entirely to the variance that took place, the variance request that took place last summer. So a previous variance is just not subject to review or modification by the ZBA in this case. If it were, anybody could appeal any particular zoning proceeding and try to go back to last summer, the summer before, the year before, and ask this body to undo decisions it made, and in some cases different bodies. I'm not sure which of the members of the ZBA was sitting on the day that the last variance was approved, but that raises another interesting question. If different members, if a different quorum of the ZBA take one action, is a different body, is a different group empowered to come and undo that decision? I don't have in front of me the record. Again, it's not in the record. Which members of the ZBA made the decision, but it's an interesting question. Can a different quorum, can a different body sitting in this case undo a decision that was made in October by this body, perhaps by a different group? I don't know the answer. Mr. Mayfield hasn't offered an answer. He sure hasn't offered authority for how it could happen. But on October 28th, 2020, this body unanimously approved that variance. And nobody was deceived. I asked Mr. Wes Munzel in this case, in the hearing just a few months ago, whether he was aware of the scope of the property that was owned by Ms. Johnson at the first hearing, and his answer was yes. He said the first thing he does with essentially every any variance or any request that comes before him, one of the first things he does, and I'm paraphrasing here, I'll give you the reference to the record where you can go look it up yourself. But he said basically, yeah, I always go look. First thing I do is I go look at cages, and so I see, just orient myself to the project. And we did that. Right there on the record. We took note of the fact that on the cages map, Ms. Johnson's property is exhaustively included. The cages map shows all 7 lots, or it's either 6 or 7 lots. There are multiple lots that she owns, and so Mr. Munzel said right there, when I looked at this, I would have known that even though only 1 lot was at issue there, I would have known exactly the scope of the property owned by Ms. Johnson, and therefore Mr. Munzel was not deceived. Mr. Sturkey, the zoning hearing examiner in this case, heard this same argument from Mr. Mayfield and Ms. Gossiger at the variance hearing itself, and he was not convinced. If Mr. Sturkey had been deceived, if at that time he was learning that a fraud had been committed on him, if we had pulled the wool over his eyes and he learned about it in this proceeding, he could have done something about it, but he did not. Mr. Sturkey was not deceived. No fraud was committed on Mr. Sturkey. Everybody knew exactly what was at issue in the last hearing. There is a reason why we didn't discuss the pool house in the previous variance request. The pool house was not at issue. There is a reason why we did not show photographs or diagrams of the pool. That is because the pool was not at issue. The variance request that previously came before this body and which was approved unanimously by this body related to the residence, related to the house. And it dealt not with the side lot lines, but the rear lot lines. The variance that was sought in that case also involved the replacement of an existing structure, by the way. And it had to do with the lot line that actually borders the Mayfield Gossiger property. And that's what we focused on. There was the reason why no representation was ever made that the improvement to the main house couldn't be done because there's no space to the side lot line. That just wasn't an issue. The proposal in the previous proceeding had to do with how close the improvement was going to be to the rear lot line. So that's what we discussed. But along the way, again, nobody in fact was deceived because Ms. Johnson's architect actually did discuss what alternatives they had considered in the improvement of the property. And she discussed putting it to the side. And the reason she said that she didn't want to do that had nothing to do with crossing a lot line. She said it was impractical for the design of the house. She didn't want to put a garage next to the living room. They wanted it to be over near the kitchen where it already connected to an existing carport. The main reason she didn't want to put it there had to do with the level, the grading on the lot. It had nothing to do with sidelines. It had nothing to do with whether or not there was room on the side for that expansion. But again, nobody was deceived. No misrepresentations were made. I said earlier that just to make sure that I get this, the place in the record where you can find Mr. Munzel saying that he reviewed the Cagis map and that he was aware of that. It's in we filed a copy of the record in this case, and it's found at page 171 to 172. Just so we're clear, there's two sets of page numbers in there. So it's in the transcript at page 107 and 108. But there's two sets of page numbers there because there's the transcript in the record. At one point in their argument, Mr. Mayfield suggests that there is something nefarious or there is something devious about the fact that these variances came before the zoning hearing examiner in two separate requests. And there's simply no legal reason why two variances on two different structures, by the way, on two different tax ID parcels, by the way, but there's just no reason why those can't legally be brought in two separate proceedings. The real answer is that Ms. Johnson's first improvement to her house was delayed because Mr. Mayfield and Ms. Gossiger appealed it. So she couldn't go get a building permit. So she began to make plans for what would happen. And in the course of those plans, in the course of meetings with her architecture that she was only having because she was then awaiting an appeal to be disposed of, they figured out what they were going to do. They figured out what they were going to do about her lodging situation. And in the course of that, she decided to do a modest rehab and update to this proceeding. There's absolutely nothing nefarious to be read into the fact that two variances were brought at two different times. There's certainly no legal reason why that can't take place. And again, Mr. Mayfield continued to refer to this as a single property, and it is all contiguous property that is owned by Ms. Johnson, no question about it. However, it is comprised of 6 separate parcels, which are defined by the Hamilton County auditor and engineer as such. And that's why that's why we dealt with them in the previous proceeding in that way, because we had no choice. The lot lines are defined by the engineer. We're stuck with it. So although it is a single property for zoning purposes, what Ms. Johnson and what Ms. Noble in each case had to deal with were the tax ID parcels. And as part of that, Ms. Johnson has agreed, by the way, to execute a covenant that will link these two parcels together, that will link the pool house together with the main residence. That was at the request of the zoning hearing staff. And again, the zoning hearing staff essentially came up with this idea. They looked at this project and they said, well, if we have to, if this is a house, if this is a separate residence, then you're going to have to knock out all those trees, and we really don't like that outcome. It really showed some sort of, I thought very pragmatic thinking by the zoning staff. They said, well, let's just treat it as an accessory structure. But even as but even there, it didn't. In order to make it fit, that's why they came up with the variance idea, because if you think about it, it's a bit odd that this structure that already exists, that's been there for 60 years, needs a variance to be placed to the side of the house that has also been there for 90 some years. Because the variances that were granted here were two. One was for the size of the improvement, which I already addressed. The second one was for the location. They considered it to be in the side yard, even though it's on its own parcel. So, but along the way, in order to give the zoning staff assurance that this is indeed an accessory structure. Ms. Johnson has agreed to a substantial concession in that she'll execute a covenant that assures that the pool house cannot be conveyed separately from the main residence. I thought that was a very generous concession on her part. I thought it was very pragmatic on her part, but it shows her intent here. If Ms. Johnson's intent was simply to press her way through and maximize, even to maximize the value of her property, she'd be treating this very differently. All she wants is to make a relatively modest upgrade to a structure that's been there for 60 years and hasn't been updated in all that time. So I'll conclude by saying the appellant has failed to meet their burden of proof here. We heard nothing that actually challenges the reasoning of Mr. Sturkey in his granting of this variance. No challenge of the legal standard. And we believe that Mr. Sturkey, again, did a sound job supporting his findings with the evidence on the record. If there are any questions, I'll be happy to take them. Thank you for your time. And again, I'm really sorry for the technical difficulties I've been experiencing. Thank you for your patience.
Does anyone have any questions? Any board members? Mr. Mayfield, you have an opportunity for rebuttal.
So I'm just going to start by reading the key to the practical difficulty standard, which comes verbatim from the Duncan versus Middlefield ruling, which is the controlling law of the land in Ohio. Here it is. The key to the practical difficulty standard is whether the zoning requirement as applied to the property owner in question is reasonable. Now let's apply that to the property owner in question here, looking back to the previous variance request. If you apply it to the property owner in question, this is a property owner who owns 2 acres to the right of her house. Those 2 acres include a pool and a pool house accessory structure, a platform tennis court, and vast acreage relative to surrounding neighbors of wooded property, beautiful gardens, sculpture gardens, etc. Applied to the property owner in question, the variance request grant for a 32-foot variance of the 35-foot setback, rear setback requirement fails. It completely fails. The reason why Mr. Linneman and the applicant did not include a description of the entire property is because they knew that it would fail if it were included. That's the reason why it wasn't included. I would like to say that I agree with Mr. Linneman. He's completely mischaracterized what our purpose is here today. Our purpose is to show that the way they've described the property, 9 Far Hills Drive, in order to justify the pool variance request is accurate. It's largely just. There are some issues that were addressed at the ZHE hearing relative to converting this accessory structure into a single family structure on a single SF20 piece of property. That's a separate issue. The general gist of the request has merit. There's no question about it. The issue at stake today is their description of the property for this variance request exposes the fact that their initial variance request was put forward fraudulently. And the information that was put forward describing a lot that was 107 feet wide by 90 feet deep, as opposed to a lot which is truly 700 feet wide. Most of that area to the right of the house. Sorry, I lost my train of thought for a moment there. What's at issue today is not whether the variance request for the pool house has merit. It does have some merit. The issue is that their description of the property in the pool house request completely contradicts their description of the property, its size and shape, the constraints that were faced by Ms. Johnson when she came before the ZHE and then again before the ZBA to request a massive variance to the rear setback requirement. That description proves indisputably beyond a doubt that their initial description of the property was false, and it was deliberately false. And Mr. Linneman, as an officer of the court, has a duty of candor to provide to the tribunal in question, initially the ZHE and subsequently the ZBA, any information that is material to the key to the standard that controls the decision-making. And he failed to do that. The only reason the question of the extensive nature of the land came up at all was anecdotal evidence provided by Ms. Gosiger in the initial hearing that we couldn't because the hearing happens quickly. You can't, head out and verify Cage's plot lines and such in the midst of a ZHE hearing where you only have a few minutes to get your points across. The only reason the city had any information at all about the more extensive nature of the 9 Far Hills Drive property is because Ms. Gosiger was friendly with Mr. and Mrs. Johnson, Judith Johnson's parents, and had been to parties on the property, including parties at the pool house, where it was obvious that this property had an accessory structure 300 feet away from the main house as you travel to the right down Far Hills Drive. So this applicant and this lawyer deliberately obscured the true nature of the constraints faced by the relevant property owner. And Wes Munzel relied on that description of the property. In fact, he repeated it. If you read the original report, which is the primary evidence that Mr. Sturkey considers in his decision-making, he essentially quotes the description of the property as one which is 170 feet wide, 90 feet deep, with no room to build to the right and only room to build to the rear. It's false. Now, it's not unusual, it seems to me, for somebody in his capacity to rely on the veracity of information provided by an applicant for a variance request. He does the same thing when I come before the city as a builder and I provide him with drawings describing the picture and where it sits on the lot. He relies on my description of the property, my description of the building, how close it is to the property lines, and he doesn't go out and do a massive independent investigation of the nature of the property. He relies on that, just like that would be the case in any administrative body that's passing judgment on a variance request or a patent. They rely on the veracity of the people who are making application and the candor of the lawyers who are presenting the case. Now, if you go to his administrative report provided to Mr. Sturkey, both in this case and the previous one, you can see that he totally relied on the descriptions of the property provided by the applicant, argued by Mr. Linneman. He completely relied on it, and he provided that information in his administrative report and recommendations for approval to Mr. Sturkey. Now, Mr. Sturkey is constrained by the rules of judicial conduct, in particular Rule 2.9, which disable him from making any kind of independent exploration of the evidence. Mr. Linneman is correct. He is confined to the evidence that was judicially noticed at the time of the hearing, most of which was the evidence provided by Mr. Munzel to him in his administrative report, which itself relied upon the veracity of Ms. Noble's description of 9 Far Hills Drive and Mr. Linneman's arguments, given that description and the limitations that the description implied. So What we're asking here today is for this body to recognize, take notice of the fact that that constitutes a fraud. And if it hadn't been for the diligence of Ms. Gosiger, and I would say myself, none of this would have come to light. If somebody looked to the original next year, was doing a review of decision-making on the part of the city around variances, and they looked to the original variance and the administrative record that's there, in the absence of Ms. Gosiger's diligence and mine, then that record would look perfect. Because yes, if Ms. Johnson lived on a lot that was 90 feet wide by 100 or 107 feet wide by 90 feet deep and wanted to put a new garage on, and the only place to do it is in the rear of the house, it seems like a totally just, meritful request that the city should consider. Whether they grant it or not is a different question, but it's, as Mr. Linneman argued in the earlier proceeding and also argued on March 24th, it's exactly the kind of case that should be considered for a variance, except that it was based on a false description of the property. This body is a statutorily created judicial body. And as such, it is constrained, just as Mr. Linneman noted, to particular types of considerations, to reviews of the record, typically, with the exception of a case where fraud was the source of the original judgment. Everything goes out the window, and the jurisprudence around this dates back to the Magna Carta, essentially, that courts have an inherent power, which is not of statutory creation, to take notice of a fraud and to take notice of a violation of a lawyer's duty of candor before the tribunal. And they have the right and the power to vacate previous orders from a different, in this case, if evidence of that fraud subsequently becomes available outside of the record of that original case. The jurisprudence around this is absolutely clear. It's been litigated all over the country, in state courts, in the district courts, in the circuit courts, and at the level of the Supreme Court. And it's totally clear. Some of the case law around this is in my written submission. So you could review that if you want to see citations to some of the law that addresses this issue. I would like to take a moment to bring to your attention another area of less than candid argument put forward by Mr. Linneman, both in this case and in the previous case. He has argued that neither Judith Johnson nor her predecessors in title created any of the issues that she faces in terms of hardship, given the constraints that the zoning code imposes on this neighborhood. He's made that argument, and the city has relied upon it. And in fact, it was essentially reiterated by Mr. Sturkey in both of his hearings, when neither of them know whether or not it's true that the modern zoning code wasn't in existence at the time Ms. Johnson's predecessors in title made change to their property. That's his basic argument, is that her predecessors in title did not cause the hardships which she faces, which justify the application of the practical difficulty standard in both these cases.
Mr. Mayfield, if I could just interrupt you. This
Yeah.
is rebuttal, so it's just responding to Mr. Linneman's arguments that he made. Okay, thank you.
Okay, that information is discussed in the written material that I submitted. So I'll leave it at that then. Thank you very much again for your time. I would like to just make one note. I believe that Ms. Johnson has herself been truthful in all of her statements before the earlier body, the earlier instance of the ZHE hearing, and in the most recent one. Whenever asked a question, for instance, about whether or not her property already had conservation easements on it, then she immediately answered yes, there were additional easements comparable to the covenant that she's agreed to it in this case. Can't say the same thing about Mr. Linneman or the applicant, Ms. Noble, who, when asked that question about that at the most recent hearing, were silent. Once again, silent. And I'll finish with this. That's relevant because the reality is that Mr. Linneman, in his argumentation, has presented a total red herring argument that Ms. Johnson is somehow giving up a property right, that she otherwise would enjoy, and is making a great concession to the neighborhood by treating the pool house as an accessory structure, and rather than treating it as a separate property, which is its own SF20 house. It's a complete red herring. Ms. Johnson, her goal, and the conservation easements that Mr. Linneman and Ms. Noble were silent about show that she has always wanted to maintain this property as a consolidated 2.4 acre estate, and that her intent with the conservation easements and the covenants are to ensure that it will always be the wonderful 2.4 acre beautiful estate that she and her family have always enjoyed. So it's completely false that Ms. Johnson is being generous. You can't be generous in a situation like this when you've essentially already got what you want, and the thing that you're supposedly giving away secures what you want, which is a covenant which will require that the pool house not be sold as a separate piece of property relative to the main house, which it's an accessory to. And furthermore, the reality is, and the thing that's relevant to this particular case, and the reason why this case has merit, the ZH 20210016 case, the most recent one, the pool house case, is because the pool house is not a separate single family SF20 residence, as Mr. Linneman now argues. It has always been an accessory to the main house. It's always been that. Historically, the Johnson family has treated it as an accessory. And Ms. Johnson testified to the fact that it was a pool house. It was a place where you went to change your clothes, take a shower after you swam, take a shower before you swam, whatever. It was an old school pool house accessory to the main house. It's a complete misdirection and red herring to suggest otherwise. And that's actually why the variance request has merit, because historically it always has been treated as an accessory. It always has been an accessory. And the unique size and shape of 9 Far Hills Drive justifies it being treated as an accessory. That's the basis of the case. And that's the case that was put forward, not Mr. Linneman's, that was put forward, Mr. Linneman's most recent argument, that was put forward by Wes Munzel, that this is a grand estate, 2.4 acres, and these property elements have always been part and parcel of one single grand family estate in Hyde Park. And because it has those special attributes, the city is required, when trying to enforce the spirit of the zoning code, to permit her to treat it as an accessory structure. I completely agree with that. So Mr. Linneman has totally mischaracterized it. The point is that is an accurate description of the property. That description of the property justifies and provides merit to this case, but it shows that the previous description of the property was fraudulent, false, and put forward in order to make an essentially meritless variance request appear as though it has merit. And if it hadn't been for the diligence of Ms. Gosver and myself, that would have all gone unnoticed. Thank you very much.
Thank you. Are there any questions for Mr. Mayfield? Okay. Hearing none, we're going to proceed and hear argument on the cross appeal, which is on the sole issue of the restriction that was placed by the zoning hearing examiner regarding short-term and long-term rentals on the pool house. We will start with Mr. Linneman. Mr. Mayfield, you'll have an opportunity to provide a response, and then Mr. Linneman, you will have a right of rebuttal. But I do want to remind the parties that this argument is limited to this sole issue. Okay, and you have been heard on the other issues. Go ahead, please proceed, Mr. Linneman.
Thank you.
Excuse me, can I have 1 moment? I just need to step away from my laptop for 1 moment before you go on. Do you mind? I apologize.
No problem. No problem. Thank you.
Thank you. And just so I understand, this is the second case number that we're starting on now?
That's correct.
Okay, thank you. I just want to make sure I've.
All right. I think we're ready and you can proceed.
Thank you. Okay, so this is a partial appeal. The only thing at issue in this appeal, which was submitted by Ms. Johnson, has to do with what we'll call condition number 2 that's contained within the zoning hearing examiner's decision. It was a condition imposed, and that it's numbered number 2 in the decision. That's why we called it that. It's at the record in the copy that we filed at page 9 in the record pagination. I'll read it briefly just to so that everyone's familiar with it at the top of our heads. The condition imposed as a part of the grant of the variance was as follows. The owner may not rent the pool house as a short-term or long-term rental property or rent the pool house through any third-party rental company. And that end quote. So then our objection to this is that we believe that this condition is excessive and in fact exceeds the powers held by the zoning hearing examiner in this case. This property is located in the SF20 district. It's a residential district, and the SF20 district contains absolutely no restrictions on rental of residential property. It is a permitted use in all forms. In fact, I asked at the hearing on this case, I asked Mr. Munzel if there was any limitation in the entire zoning code on the use of property for rental purposes, because I couldn't find one. I'd looked for one and I couldn't find one. And Mr. Munzel testified that he was aware of none. So this is a very unique and far-reaching restriction. It's a restriction of a right that is universally permitted by the zoning code. So it's very extreme. Not only that, it affects what is a piece of the fundamental property right. If the zoning code as a whole creates no power to restrict a property owner from renting property, and if in this zone there is no restriction on using a residential property for rental purposes, then this is an inappropriate and excessive restriction. the decision, in addition, it's an area that's already governed, that city council has already given authority over to another branch of government. Chapter 874 was specifically passed by city council fairly recently. It's just a couple years ago, I believe. But chapter 874 governs registration of rental properties. It's the only governance of rental property that I'm aware of, certainly. And I asked Mr. Munzel the same question. He seemed to concur. But specifically, then also, what's more, specific authority, regulatory over this area is given to a different city officer, not the zoning hearing officer, but the director of buildings and inspections. So by imposing this restriction, the zoning hearing examiner has gone further than the powers existing in the zoning code, and also has gone into an area that is governed by a separate agency of the administration, by the Cincinnati Municipal Code. As a constitutional matter, this is renting property, using it for an economic purpose, is one of the fundamental constitutional pieces of the bundle of rights that come with property ownership. So this is a violation, not just at the level of the code, but also on a constitutional level, whether you under both the Ohio and federal constitutions. Now, let me make clear that it is not Ms. Johnson's intent to rent this property at all. She stated on the record she does not intend to use this as a rental property, and in fact, she intends to use it just for her own use. She conceded that point readily. This is a question of this is a question of the authority of the zoning hearing officer, the power vested by the code, and the constitutional rights under both the Ohio Constitution and U.S. Constitution held by Ms. Johnson. Finally, though, one separate aspect here, again, it only adds to the severity of this restriction, because this is again a home or a structure which is on a separate parcel. So there is an individual property right that is vested with this parcel and on the pool house itself under the zoning code. So that makes the restriction all the more severe, because not only would she have the right as an accessory use, but she has it as a property owner with a separate and independent lot. Thank you.
Thank you. Are there any questions from Mr. Lindeman? All right, Mr. Mayfield, would you like to respond?
I just have a couple of points. First of all, I think that the general thrust of Mr. Lindeman's argument is correct. That the basic right of a property owner to rent different elements of their property is not something that can be taken away. Certainly not taken away lightly. The issue that needs to be considered here is whether or not the rights that were granted through the variance approval included rights that don't attach to SF20 properties, and the right that right that doesn't attach is the right to have two single-family residences on one SF20 piece of property. And the city has agreed to this covenant. It's all assuming, of course, that you don't decide to vacate the previous decisions, this one and the prior one, which I think you should. But the city has permitted Ms. Johnson through the ZHE to add elements to a pool house, which is, as she described, the place where they went to change their clothes and get ready for a swim, or to come out and have a relax on the deck after a swim, take a shower, etc. To convert that into a single family, convert it such that it has elements of a single family residence. And it seems to me that that is an area that the zoning authorities have direct control over through the code. And when they grant an exception to the code, which would allow Ms. Johnson to add elements like a bedroom and a full kitchen, not just a small kitchenette, and a full bathroom that attaches the bedroom, not just a place where you went to take your shower to change your bathing suit out, then the zoning body is permitted to attach constraints. And the constraint here would not be that Ms. Johnson couldn't rent out the pool house as a party venue, maybe to some neighbors who wanted to have a nice big party for a family coming into town or something like that, but that she can't rent it out as a single family residence where somebody would use it as a single family residence on a piece of property, which is one SF20 property. That is a restriction, it seems to me, that is totally legitimate, given the fact that she has asked them to allow her to add elements of a single family residence to an accessory structure. And the whole point here, and Mr. Linneman keeps going back to the fact that this is a separate parcel. The whole point here is that it's part and parcel of one piece of property, and both Ms. Johnson and the city agree that it is not a separate SF20 structure. It's an accessory structure and always has been an accessory structure to the main house. Thank you.
Thank you. Are there any questions for Mr. Mayfield? Mr. Linneman, you have an opportunity for rebuttal.
Okay, first, I must contest just on the facts. Mr. Mayfield is wrong. There is no single element that is being added to this home as part of this improvement that doesn't already exist. There's already sleeping quarters. There's already a kitchen. There's already bathrooms. There's already showers. It's mostly just a modernization. But there is no new element of a single family residence, as Mr. Mayfield characterized it, that is being added. Now, all of those things already exist. That is in the record. There is a kitchen, there are bathrooms, there are sleeping quarters. That's why the zoning staff were ready to treat it as a single family residence initially. But second, with regard to the concessions, I'll just note that it is again Ms. Johnson's intention to give the neighborhood what it wants through this project. The testimony that's in the record in the original hearing will make clear that again, all the neighbors are agreed that the worst thing that would happen is that Ms. Johnson be forced to take down all the trees and take down the privacy fence. She's trying to do an improvement that will not change the view substantially that her neighbors are looking at. So when it comes to the concessions that are being made here and the design of the project as a whole, that's what it's designed for, to reduce the visual impact on the neighbors who can actually see it. And I would add Mr. Mayfield and Ms. Gossiger are not in that camp. Their home does not could not visually contact this pool house. Thank you for your attention. With that, I'll conclude.
Are there any final questions from any board members? If not, I'll entertain a motion to adjourn to private deliberation.
I motion to adjourn to the deliberation.
Second.
All right, so first by Mr. Moran, second by Ms. Powell. Roll call, Mr. Moran.
Aye.
Mr. Zelasco.
Aye.
Ms. Powell.
Aye.
I vote aye